welcome everyone to the March 20th meeting, the public meeting for the Loft Board. We'll start by looking at the minutes from the last meeting, the February 2013 public meeting, and I will ask for any comments from the board. Seeing none, I'd like to ask for a motion to accept the minutes. Chief Ford, thank you. And a second, please. Yep, Mr. Barrowitz, thank you. Ms. Mark, please call the poll board.
Mr. Barrowitz?
Yes.
Mr. Mayor?
Okay.
Chief Ford?
Yes.
Chairperson Ramsey?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera? Yes. Mr. Quatten?
Yes.
Mr. Shanklin?
Yes.
7 in favor, 0 against, 2 absent, 0 recused, 0 absent.
Thank you very much, Ms. Smart. I'd like to ask the Executive Director, Elaine Alexander, to give her report, please.
Thank you, Chairman. Good afternoon, everyone. Today is one of the off months for giving you the full statistical overview. That would be the buildings and where they stand, and also the cases and where we are with those. Today I'd like to give you more of an overview of where we are with the coverage applications, since we reached the deadline on March 11th for filing applications for coverage and for registering buildings. First, I'd like to tell you that we have 325 buildings in our jurisdiction. That doesn't include the 12 registration applications that we just got in and are pending. Excuse me, 248 buildings are in the 281-1 category, and 76 of the buildings came into our jurisdiction under 281 subsection 5. We have 2,557 units. Of these, 1,294 are in the 281-1 buildings, and 1,288 are in the 281-5 buildings. Now, with regard to coverage applications, for context, let me point out that from the beginning of January until February 21st, we had 15 coverage applications filed with us. During the 13 business days between February 21st and March 11th, we received 96 applications. 88 are new coverage applications and 8 are amended applications. We have docketed all of the applications, and they are now in the answer period, along with 16 other applications that were pending from the last meeting, sometime before February 21st. And we have a total now of 474 applications for coverage. These applications impact on 200 buildings. 74 of these buildings are already registered. We got 37 new buildings with the 88 applications that were just registered. Just filed. We got 37 new buildings came in under the 88 applications. So where are we with those 474 cases? 195 coverage applications have been brought to the board for vote, and they are in final. 49 coverage cases are pending, what we call on the ready list. Those have been returned to us from both. There are 14 master case coverage cases that are pending, and 35 coverage applications. The 14 master coverage cases impact on 6 buildings, and the 35 coverage applications that are in the summary calendar are impacting on 24 buildings. Finally, there are 126 coverage applications currently at oath, and 104 are in the answer period. Again, remember, I'm now talking just about the coverage applications. This is not what we had last time, which was all of the applications. These are just coverage applications. In light of the March 11th deadline, on March 12th, we removed from our website the coverage application form we added a new category, and that is an application for protected occupancy status. We do not believe that the statute of limitations limits those applications. We believe that it only dealt with units, so that those people who are already in occupying a protected unit, but are not listed as the protected occupant, still have a right to move for protected occupancy status. So we've created that new docket, which is PO. Finally, I just want to tell you that Keisha, our Secretary of the Board, will be moving on to a new job at DOB. We congratulate her for her new job, and we will miss her very much, and we thank her for all of her work. I would like to introduce you to Irma Rivera. She's going to be our new office manager and secretary to the board, and we would like to welcome her to the board. And that's my report.
Thank you, Ms. Alexander. Are there any questions or comments? Mr. Delaney?
Just a couple of questions on the circumstances surrounding the deadline, the arrival of the deadline. Somebody can apply for a covered occupancy status. What about, and have you had any questions about additional units in buildings where there's a pending application, amending applications? Because I'm getting questions about that, and some people are saying, well, the Loft Board's saying, most of what I was told the Loft Board's saying didn't make a whole lot of sense, so I'd like to hear what the Loft Board is saying.
What we're saying right now is that we're not saying, because this is something that's very, very difficult to do an analysis of. We have been trying to do this carefully. We have had maybe 3 telephone calls since the March 11th date. And we have asked everybody that called to please call us back. And Martha and I and our attorneys are all discussing, because it's not simple, the fact patterns change. Basically, what we think is that the way the statute is written and the way that the rules are written, we believe that the statute of limitation impacts on units only, not on the tenants, and whether they are protected occupants within the building. Whether a unit can be brought in that didn't apply and wasn't named in the application after the statute of limitations has run is an issue that we are discussing now. It's a complicated issue of law, and we are also discussing it with the Corporation Council. We have to look at all of our rules, so we are loath to give an opinion at this moment.
So, for example, if 3 tenants in a 10-unit building apply, and in their application they just said these 3 units are applying for coverage, as opposed to having said in their application there are 10 residential units, is that the kind of issue you're grappling with?
That's exactly the kind of issue we're grappling with. You can see how complicated it is, because on the one hand, you might have an application that had 1 applicant. Now that applicant has to say, in order to be qualified, that there are three units in the building.
Right.
And hopefully identify those 3 units. So what would be the difference between that and the building that has the 10 units, and there were 3 applicants, but those other 7 were not mentioned?
Right.
That's what we're looking at right now.
And
exactly.
then, I guess, in the latter case, we're a building with 10 units, of which only 3 applied and the others weren't really discussed. If the owner then turns around and says, okay, I'm an IMD, would he be precluded from registering the other 7 units?
That's exactly what we're discussing. And I don't have the answer for you this today.
I'm sure, yes.
And, I agree with you that these are very, very difficult issues. And and they require, more than my, just my feeling about what it should be or what it is. We need to really go and look at it in the context of the law and the rules. And knowing that we would like to be as expansive as possible, always, that's what the case law really tells us, that we're supposed to interpret our rules and our law expansively to be as inclusive as we can, while still, staying within the language of the law.
If these other 7 units are not get covered, then the city is, or the state, or whoever it is, then proliferated this idea of illegal laws, illegal tenancy. It doesn't make any sense. I mean, I can think that there would be case law to absorb those other 7 units. And you're all lawyers here, you have an opinion about it?
I have lots of opinions on lots of things, but I don't have a legal opinion on it right now. I understand, and as I said, we want to be as expansive. We don't want to come to a ridiculous conclusion. We're covering, as you say, 3 units, and we're leaving, 22 illegally occupied units. And what are we doing? We're either forcing an owner to remove those tenants or to let them stay and live illegally. That's not our goal. However, we are confined to what the statute says and what our rules say. So, that being said, we will come back to you with an answer on all of these. And if I come up with the answer, and it's a discussion that we're going to have, as I said, with the law department as well, I'll let you know as soon as I know.
Well, one would presume there's some degree of urgency here.
Yes.
That, obviously, depending on the zone the building's in, there are owners who might love to be able to register all of their units, and others who would be altogether happy not to register the other side. So, it's one of the reasons I don't know how good public policy having a deadline of this sort is, because I argue that's one. So that if you reach some definitive conclusions in between this month's meeting and next month's meeting.
I will be sure to let you know.
Thank you, Mr. Blaney. Other questions for the executive director on her report?
I have one with regard to the statement in the minutes of last month that we're going to do some contacting city agencies and community boards.
So there was, in the Community Affairs Unit, Department of Buildings, each of the members of that unit are consistently in contact with community boards. They attend the district service cabinet meetings. We did reach out to community boards via telephone and council members to make them aware of the deadline, and for the meetings that we did attend since the last Loft Board meeting, I should say that the community affairs members of the Department of Buildings attended since the last Loft Board meeting, just to be clear. That was also brought up at those meetings as well.
Is it your sense that all council officers were contacted?
Yes.
Thanks.
All right, other questions for the executive director on her report? Seeing none, we'd like to turn towards the cases in the summary calendar. There are 9 summary cases. These cases will be voted on as group. And Ms. Alexander, would you please introduce the cases to the board?
Certainly. Number 1, Raymond Gonzalez and Flannery Foster, 73 Kaler Street, Brooklyn, TR 0817. 55-65 South 11th Street, tenants. That's at 5565 South 11th Street, Brooklyn, TR 0829. 83 Meserole Street, tenants. 8391 Meserole Street, Brooklyn, TR 0864. Paulette Godfrey, Adam Engel, and Olivia Seri, 1315 Thames Street, Brooklyn, TR 1044. Gina Pham and Matthew Penrose, 98 Forsyth Street, TR 1066. Ernest Matsukawa, 41 West 24th Street, TR 1151. Gustavo Satoshi Mutsukawa, I'm sorry about that, it's 41 Matsukawa, 41 West 24th Street, TR 1152. Setsuko Matsukawa, 41 West 24th Street, TR 1153. Scott Woods, 41 West 24th Street, TR 1157.
Okay, other than pronunciation of last names, any questions about the cases?
Yeah, I have questions on two of the cases, I think. Number one and number two. In case number one, we had rejected the original stipulation of settlement. And could you just explain to me how we benefited from this exercise and what makes the stipulation of discontinuance acceptable as opposed to the original stipulation of settlement?
Well, I think that, well, I'm not so sure that we benefit other than we made sure that the public is now aware that they cannot include as part of the terms of their stipulation that they will continue to reside in the meeting space. A space that is not in compliance with any of the fire and safety codes. It certainly generated a lot of discussion. Some of the attorneys that reached out to us. So I think that that sends, the rejection of that stipulation certainly sends the message to the community that that will not be tolerated by the law board. It's not common for the tenants to withdraw their applications. I mean, there's not much we can do with, with this request to discontinue this application.
Okay. In terms of the notion that having rejected that stipulation, it sends a message to the community, have we thought about any kind of follow-up on that?
In terms of reaching out to...
An FAQ, a newsletter, I mean, it sends a message to a small portion of the community that follows this kind of thing, which may not necessarily be as expansive as we might prefer.
No, we have not done
Considered.
anything. We've not considered it. We didn't put it in that FAQ. What I think Ms. Cruz is saying is that for us, the lawful bar, the tenants' lawyers and the owners' lawyers are all now aware that this kind of stipulation will not be accepted. In addition, they're aware of the fact that we look at all of the stipulations. Does it reach the tenants necessarily? I don't think so. And if that's who you're talking about, we have not reached out to them. But those who are represented, and in fact those who have created that kind of stipulation, now know that that is not a stipulation that will be accepted.
Okay. Again, in this case, the tenant was represented by a fairly active attorney.
Yes.
Landlord, however, was represented by an attorney who's not terribly active. So I don't know, do we think that the squeals went out as to what we did loudly enough that the entire law attorney bar is aware of it?
Well, I can say that I had conversations about the issue with attorneys that were not part of this case.
Okay, all right.
Yeah.
Right, so that kind of leads to my other question, which is on the second case, where we seem to have a number of units that applied for coverage who have now settled and are going to get 2-year leases in a building that's already an IMD, with the owner promising to kind of do all the same things in a kind of sort of way to bring the building up to code, the units up to code, modifying the access provisions. And is this an acceptable stipulation? And if so, why?
Well, I'm not, well, it's not for me to say whether it's acceptable, it's for the board to say, but I could say that there's a big difference between this stipulation and the stipulation in South Elm Street and the stipulation in Keller Street, or the Mark Parish situation, which is the
Oh,
other
don't take
case.
him into just that.
Well, I think his example is a good one in that in both of those cases, which is Keller and the other case that you dealt with at the same time, neither of those owners were required to do any legalization work. They were just going to continue to live there for years on end, and the owner wasn't responsible for filing an R1 with DOB. They weren't supposed, there was just no legalization work to happen. Here, the owner has filed an R1 with the Department of Buildings. They have a permit, work has begun, which is not the same situation that's happened in Keller Street that was on the board, in the other situation that was before the board at the time.
Well, that's exactly, I'm trying to find, is there, where's the line? I mean, obviously, yeah, we'll give you a 10-year lease and you can rent the space upstairs is so beyond the pale that that's an easy one for the board to say, we're not going to look at that. But was this a close call? I mean, we seem to be setting up a parallel universe. I don't know, the stipulation is really quite remarkable in terms of, providing kind of between the landlord and the tenants through the stipulation, many of the kinds of provisions that apply to the loft law, but with the tenants saying that they're withdrawing their application with prejudice.
Yes, that's true.
So it strikes me that this is kind of a gray area here. And I just, I was surprised that this one passed muster with you guys.
And I believe that what was driving the board at the time was the concern of having people reside in a building that was, not achieving any code compliance. And that was what I don't know what the board discussing at the time. Whereas this, the owner was certainly, on their way.
Well, doesn't this kind of open up the possibility of, I say I'm going to achieve some code compliance in these units, but they're not covered units, even though I'm giving the tenant the right to sell. I mean, as elaborate a mimicking of the loft law as giving the tenants the right to sell their fixtures according to 286.6, which they're saying they're not covered by. Are these units where we will enforce legalization? The tenant, if the landlord doesn't live up to this, the tenant can't file a finding of non-compliance.
No.
You're bringing up a very interesting distinction, and I know that there are cases, I don't know, one that comes to mind, where the tenants have fought for coverage, and they have been, in the context of the conferencing at oath and outside of oath, discussing a settlement of the claims where the tenants withdraw their application. And part of the negotiations will be the building is in a zone where the owner can make it residential. And so the owner says, I will make it residential and I will give you this, 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 and this. Now, we would accept that, I would think, because the owner is agreeing to make it legal. Whether we're going to enforce that, it's going to be outside of our jurisdiction. But this is not the same situation where we have an owner that says, I am not going to make it legal, and as a matter of fact, I'm in an M zone and I can't make it legal, but you can stay here anyway. So I think that's the distinction that we're drawing.
I understand the extreme, screw the loft law, I'm going to do my own thing, and I'm going to let my tenant do his own thing. I understand that. That's clear.
Okay.
And I think at this point, dragging that into the discussion is kind of a canard in terms of getting to, I mean, is this loft law light? I mean, I think this is a very slippery slope, you know? I mean, I would think the buildings department would have some concern about this. I mean, the landlord's kind of set up a deal with, in this case, some of the units, the rest of it's an IMD, why there's this resistance to these units. But to say, yeah, you know, I mean, there's the landlord promises not to assert rights to electric heat control. It doesn't need to be registered with DHCR. And what that means in terms of the building, this portion of the building as opposed to that portion, which is an IMD, I just don't get, I'm going to vote against this particular case, and I'm going to write something on it, because I don't know why I mean, this, saying, for us to approve a stipulation that says we're going to be almost like the loft law, but not quite like the loft law, to me, that's a significant policy decision.
So it's in a residential zoning here.
He's filed it already.
I agree, and I think that even though the tenant has the right and the landlord has the right to make a legal agreement, I think that we have the responsibility to do some coordination. And it may not be the loft law, it may be the buildings department, or maybe another agency, but I do think that we have to coordinate with the other agency and have these cases flagged in some way, so that there is some follow-up, since we know that they're moving supposedly on a parallel track to legalize, and no one else knows it but us. So I think that the coordination between us and some other agency to ensure that this doesn't get lost is very important.
Yeah, I mean, the other thing is that word can get around to subsequent places, and then we're being inundated with these. I mean, I've always, as you know, a lot of these stipulation agreements have always made me very uncomfortable. Now I'm afraid that this may begin to spiral out of control. And then where are we in terms of public policy and of, what we're mandated to do to uphold the new law, the old law, both of them. So, I mean, the public policy here has to do with, as I've said before, is to have increased tenancy of those people living in lofts for a whole bunch of other reasons. Basically, it contributes to the welfare of the city of New York and mightily so. But then again, we have on here a bunch of private deals going on sub rosa that the city seems to have no control of. And because, I don't know, because of just because that's the way it works sometimes with these stipulated agreements. You're going to make agreements to anything. And would we accept anything as a stipulated agreement?
I think that you have all brought up something that's very interesting to consider, for us to consider, and I'd like to withhold that particular case until next month, and I'd like to look into it. And more important, I would like to get your view, and you're giving it to me now, because we're going to have cases coming again in the future as the one I just spoke of, where they're going to, if these parties do wind up agreeing, they'll have an agreement that would be enforceable, but not by us. And do we accept it? Do you, as a matter of policy, want us to give this to you to accept? And if not to accept, just like we're doing with the remaining cases, but to say we want to accept it with the proviso that we do X, Y, and Z. Let's talk about that. I think it's a valuable discussion to have. What you think would be the safeguards that we could attach to some kind of stipulation, and if we do that, how we enforce it. Mr. Delaney, do you have any thoughts on that?
Well, I'll tell you one thing, this is exactly why I think having this kind of discussion in an executive session would be a tremendous step back.
Nobody said we would have to do
I'm
something.
just saying, this is, for the community to be able, those of them who are sufficiently demented to want to watch a streaming video of this discussion, to be able to see what the issues are and how people feel. It seems to me, and you know, because we've discussed it in prior meetings, that when an earlier executive director tried to negotiate separate legalization deals with different timetables, some of which went outside the period at that point when the law firm was continuing to expire, where like, oh, let's make a separate arrangement and we'll give you more time because we realize you've got these difficulties or whatever it is, that didn't work out so well. So it seems to me that, if you've got one set of procedures and one maximum speed, it makes it a lot easier for the people patrolling the highways to know what the speed limit is. Whereas because when I read this stipulation, it says the owner's going to do this and he's going to do this, but it doesn't say, and if he doesn't do it, what? If he doesn't do it, what are you going to do? Because the tenants have relinquished all their rights under the law firm.
All right, so at this point, I think we should remove number 2 from the coupled summary calendar, 55-65 South 11th Street tenants. And if I can have a motion to accept the other 8 cases with that case removed. Ms. Bowman Rivera, thank you in a second. Mr. Barrett, thank you. Ms. Mark, can you please poll the board?
Mr. Ballard?
Yes.
Chief Spatafora?
Yes.
Chairperson Menschke?
Yes.
Mr. Delaney?
Yes.
Ms. Golden Rivera?
Yes.
Mr. Conley?
Yes.
Mr. Schechter?
Yes.
7 in favor, 0 against, 2 absent, 0 recused, 0 abstained.
Mr. Chairman,
Yes, Mr. Barrett.
you really should say that we're tabling this.
Yes.
Okay. So
Because we're tabling, we can bring it up. If we remove it, you don't necessarily put it in Robert's rule, that's bring it back. And the chair can table without a vote.
Okay, thank you. And so I will be tabling summary calendar case number 2, 55-65 South 11th Street tenants. Turning to the master cases, we have 8 default cases and 2 substantive master cases. The default cases, Ms. Alexander, please introduce the default cases.
Yes. Number 10, Paul Nocera, Anne Marie Spencer, James Wilkerson, 950 Hart Street, Brooklyn, TA 0190, TA 0192. Number 11, James Michael Wilkerson, Annie Spencer, Thomas Miller, James Ewing, Sarah Butler, and Antoinette Johnson, also 950 Hart Street, Brooklyn, TR 0839, TR 0943. 12, Paul Crawley, Clifford Jackman, and Charles Smith, 4143 Division Street, TR 0860. Uriel Marachi, 525 West 29th Street, TR 0866. Benjamin S. Jones, 1196, 1198 Metropolitan Avenue, Brooklyn, TR 0888. Bethany Romanowski, Michael Greathouse, Cindy Foster, Mark Foster, Dana Canalou, Berestra, Meredith Pingree, and Kevin Blacker, 1083, 1095 Flushing Avenue, Brooklyn, TR 0899. J. Sebastian Tang-Uselli, 269 Mesro Street, Brooklyn, TR 0905. And number 17, Chadwick Tyler and Hannah Mission David Struthers, 269 Mesro Street, Brooklyn, TR 0907 and TR 0909.
Thank you, Ms. Alexander. Questions regarding these cases?
Just one.
Yes, Mr. Miller.
Just one. 269 Metzerow Street. On that one, the application alleges 6 residential units plus a hostel. Now, in the kind of post-deadline world, will the board, number 16, does the board have any plans to track this kind of building, or does it go on our radar, or have we given that any thought?
I believe this is the building that just it was registered today, and it's registered as 18 units.
Oh, it was registered today.
Yes.
Good.
Not that it was filed today, but the
It
application
was
was
the
processed.
process, the
The
registration.
ID number for the.
So perhaps
So the others.
the
probably-
individuals desire to pursue this, just kind of figure it out. Okay, all right.
Thank you. Do we have a motion to accept the cases? Mr. Fogg, thank you. And a second? Thank you, Mr. Shacker. So, okay, this one, yes. Would you please poll the numbers?
Mr. Barrow.
Yes.
Chief Spatafora.
Yes.
Chairperson Rashid.
Yes.
Mr. Delaney.
Yes.
Ms. Gordon Rivera. Yes. Mr. Fogg.
Yes.
Mr. Shannon.
Yes.
7 in favor, 0 against, 2 absent, 0 recused, 3 absent.
Thank you, Ms. Smart. Ms. Alexander, please introduce the next case. Master calendar, please.
Yes, this is our first master calendar case, and it is John P. Romano, 265-271 Douglas Street, Brooklyn, TR 0906. Ms. Cruz, would you please present the case?
On May 23rd, 2011, John Romano, the tenant of the 3rd floor of West Unit at 269 Douglas Street, filed an application seeking a finding that 265, 267, and 269 Douglas Street constituted a horizontal multiple dwelling, and that his unit is entitled to Article 17 protection pursuant to 2815 of the multiple dwelling law. In his answer, the owner disputed the tenant's claims. Judge Lewis bifurcated the proceeding and entertained first whether the buildings constitute a horizontal multiple dwelling. In her report, Judge Lewis recommended a finding that the buildings are not a horizontal multiple dwelling. In support of her recommendation, Judge Lewis relies primarily on 3 facts. That 269 Douglas Street is not immediately adjacent to 265 and 267 Douglas Street and are separated by an alleyway. 2, that the passageways between 267 and 269 were not used during the window period. And 3, that the buildings have separate building systems. The staff recommends that the board reject Judge Lewis's recommendation. The factors for determining whether a structure or structures are a horizontal multiple dwelling are found in Section 208 of the Loft Board rules. In applying these factors, the Loft Board considers the facts in each case and the different combinations that these cases present. There's no one factor that has been found to be determined. The record shows that in the 1960s, the former owner purchased 265, 267, and 269 Douglas Street, and in 2009, the current owner purchased the buildings by a single contract of sale. Therefore, for at least the last 45 years, the buildings have had common ownership. Relying on factor B of Section 208A.1.3, Judge Lewis concludes that there are 2 buildings that are separated by an alleyway. Therefore, they cannot be part of a horizontal multiple dwelling. However, there's nothing in the language of 208 that requires buildings to be immediately adjacent to one another or have common walls to qualify as a horizontal multiple dwelling. The factor in B is only triggered if the buildings in question are immediately adjacent to or share a common wall, not that they must be in order to qualify as a horizontal multiple dwelling. Judge Lewis also found that there was insufficient evidence that the passageways between 267 and 269 Douglas were accessible during the window period. However, the use of the passageways during the window period, while relevant, is not critical to a finding of that the buildings are a horizontal multiple dwelling. Of equal importance is that the existence of the passageway establishes a connection that is indicative of the operation of the buildings as a single entity. As part of the analysis, the Loft Board also considers the building systems, the physical structure, and any other addition the buildings operated as a single entity. Although Judge Lewis focused on the differences in these areas, This record shows that there are also commonalities. For example, the buildings share a fire escape. In case of an emergency, the second floor occupant of 269 Douglas would have to exit the second floor fire door to use the fire escape of 267 Douglas. The other addition that the buildings operate as a single entity include that there's a common boiler, there was a common steam pipe that goes through the buildings, there's a common fire protection system, and one electrical account for this fire system. When the owner purchased the buildings, he secured a purchase money mortgage to cover all of the buildings, and it also obtained one insurance policy for all of the buildings. In notice to the tenants, the new owner referred to all of the buildings as a single building. The owner also appointed one superintendent to maintain the buildings. The record also shows that the former owner and the owner both regard the building as a single building in official papers. Prior to 2009, the former owner obtained an appraisal for the building referring to 265, 267, and 269 as one building. In court papers, the former owner identified the buildings as one building spanning from 161 to 269 Douglas Street. And in 2010, the owner identified the buildings on the future lease as one building. Based on this evidence, the buildings had common ownership, management, common boiler, and other shared building systems, and one mortgage. The staff recommends that the board reject Judge Joseph's recommendation and find that the buildings are a horizontal multiple dwelling and remand the case to oath for a hearing on the remaining coverage issues.
I just like to say that I tried to Google this building, and then sometimes those Google maps don't work terribly well. But I didn't see any alleyway. I saw these buildings contiguous. Now, maybe there was no alleyway in the rear, but I didn't see it. Now, maybe I didn't get it properly. But anyway, just saying.
I'm sorry, just before we start to discuss this case, I should disclose that the former owner, Robert Daver, is a member of the LLC that owns my building, so he is my landlord. I've never discussed this case with him, this building, and I don't see any reason that I can't participate in this discussion, but I just want to disclose it. Particularly since he's testifying for the tenant, but I'll be hard pressed to be prejudiced against him.
Thank you for pointing that out, Mr. Delaney. Any other questions, comments about this case? Is there a motion to accept the case? Thank you, Mr. Delaney. And a second? Thank you, Mr. Barowitz. Mrs. Smart, please call the board.
Mr. Barowitz?
Yes.
Chief Spatafora?
Yes.
Chairperson Massey?
Yes.
Mr. Delaney?
Yes.
Ms. Golden? Yes. Mr. Foggen?
Yes.
Mr. Chapman?
Yes.
Mr. Chapman? 7 in favor, 0 against, 2 absent, 0 recused, 0 abstained.
Thank you, Ms. Smart. Ms. Alexander, please introduce the next master calendar case.
The next master case is Alon Cohen, 57 J Street in Brooklyn, TR 0988.
Ms. Cruz, will you present the case, please?
On February 8th of 2012, the occupant of 4C of 57 J Street filed an application seeking coverage for the unit and protected occupancy status pursuant to 2815 of the multiple dwelling law. The owner raised several arguments in opposition to the coverage application. First, he argued that the tenant should be deemed a commercial tenant because he entered into a stipulation in the commercial part of the housing court in March of 2010. Second, he argues that the tenant's unit is not an IND because there wasn't sufficient evidence that the unit was converted to residential use. Third, he argued that the tenant did not occupy the unit as his primary residence. In the report, Judge Addison recommends a finding of Article 7C coverage for the unit, pursuant to 2815, and the finding of protected occupancy status for the tenant. In her analysis, Judge Addison correctly rejected the owner's argument that the tenant was a commercial tenant. She found that although the stipulation was so ordered by the Supreme Court judge, there was no final resolution of the rights in the holdover proceeding, and that the stipulation did not preclude the tenant from applying for Article 7C coverage. Based on the credible testimony of the tenant and the tenant's witnesses, Judge Addison probably found that the unit contains sufficient residential fixtures to indicate the conversion to residential use. The tenant testified about the unit's condition when he first rented it in 1987, and how he purchased a refrigerator, a kitchen sink, shelving cabinets, and mirrors in order for him to use the unit residentially. Judge Addison also credited the testimony of the tenant's two witnesses who confirmed the tenant's residential occupancy of the unit. Lastly, the owner also claims that the tenant does not occupy the unit as his primary residence due to his citizenship. Judge Addison relies on 209 of the Loft Board rules to reject the owner's argument and find that the tenant is the protected occupant of the unit. Citizenship is not a factor in determining protected occupancy status pursuant to the Loft Board rules. The staff recommends that the Loft Board find that the unit is covered pursuant to 281.5 and that the tenant is the protected occupant.
Thank you. Questions or comments regarding this case? Seeing none, is there a motion to accept the case? Thank you, Mr. Foggy, and a second. Chief Spotter Ford, thank you. Ms. Smart, please pull forward.
Mr. Garrett?
Yes.
Chief Spatafor?
Yes.
Chairperson Mansky?
Yes.
Mr. Delaney?
Yes.
Ms. Golder Rivera?
Yes.
Mr. Foggy?
Yes.
Mr. Shepherd?
Yes.
7 in favor, 0 against, 2 absent, 0 recused, 0 abstained.
Thank you, Ms. Smart. And the last two cases are removal cases and will be voted on as a group. Ms. Alexander, could you please introduce these cases?
Yes, Kenneth Dubois for 134 West Broadway, LLC, 134 West Broadway, LE 0623, and 111 Broadway Realty Corp., 111 Broadway, Brooklyn, LE 0624.
Questions or comments regarding these cases? Seeing none, is there a motion to accept? Thank you, Ms. Golder there. And a second, please. Mr. Foggy, thank you. Ms. Smart, please pull forward.
Mr. Garrett?
Yes.
Chief Spatafor?
Yes.
Chairperson Mansky?
Yes.
Mr. Delaney?
Yes.
Ms. Golder Rivera?
Yes.
Mr. Foggy?
Yes.
Mr. Shepherd?
Yes.
7 in favor, 0 against, 2 absent, 0 recused, 0 abstained.
Thank you, Ms. Smart. That concludes the agenda for the meeting. I'd like to take this opportunity to wish Ms. Smart good luck and congratulations in her new endeavors, and welcome her on board for our next meeting, which will be, by the way, April 24th. And I thank you all, and I need to sign.
You have to sign
Yes.
your sheets.
Thank you very much. Good luck.
We done?
One word for me.